Grab some seats. It's really terrific to have this particular panel. This is a panel that, I almost hate to say this, if I was smart enough, I want to be on this panel because this area just so intrigues me so much, but I'm not smart enough, so fortunately we had available to us the actual really smart people. And our moderator for this panel is Professor Margaret Hugh. She's a visiting assistant professor here at Duke, and my good buddy, a couple offices away. And she went to Duke University Law School, and she is teaching, she's taught immigration law, but she's teaching a seminar, a very interesting seminar this semester on cyber surveillance and cybersecurity. And she is unfortunately leaving us, and she's going to a professorship at Washington and Lee. Margaret?
Thank you so much, Charlie, and thank you very much for having this panel. It's a great honor and privilege to be able to introduce our very esteemed panelists that we have here today to help us sort through these issues of technology, privacy, and security. And I'll just introduce them in the order that they'll be speaking. First, we'll have Ms. Catherine Crump speak. She's a staff attorney with the American Civil Liberties Union Speech, Privacy, and Technology Project. She litigates issues ranging from challenges to invasive government surveillance to the protection of the right to engage in political protest to accountability for police officers' use of excessive force. And her current cases include constitutional challenges to the government's assertions that it may legally engage in suspicionless searches of laptops at the border and in geolocational cell phone tracking. Then next, we're going to hear from Colonel Dawn Zoldi. She is Chief of Operations Law at Headquarters Air Combat Command, ACC. She serves as Chief Counsel to the ACC Commander and staff on all international intelligence and operations law matters. She has served as a faculty member at the United States Air Force Academy and adjunct faculty member at the Air Force, Judge Advocate General School. She's the author of numerous publications, and she was deployed in support of Operations Enduring Freedom and Iraqi Freedom. And then finally, we're going to hear from Professor Nita Farahany. She's a professor of law, professor of genome sciences and policy, and professor of philosophy at Duke University. She's a leading scholar on ethical, legal, and social implications of biosciences and emerging technologies, particularly those related to neuroscience and behavioral genetics. And in 2010, she was appointed by President Obama to the Presidential Commission for the Study of Bioethical Issues and continues to serve as a member. She's also a member of the European Association for Neuroscience and Law and a board member of the International Society for Neuroethics. So it's a very, very esteemed panel that we have here today. So without further ado, let's start with Catherine Crump, who's going to give us an overview of some of these surveillance technologies.
Well, hello. As was mentioned, I'm a staff attorney with the ACLU's Speech, Privacy, and Technology Project, which has been a tremendously fun and interesting job over the last 5 years in particular, because being a privacy advocate in this day and age seems like sometimes quite the quixotic endeavor. But one of the fun challenges of the job is to try to figure out how to take old, traditional values, the Fourth Amendment's protection against unreasonable searches and seizures, and to attempt to make sure that that value continues to be honored in an era where it is easier to collect information about people than ever before. So I thought I'd start out by giving a broad overview of the types of challenges we face when trying to protect privacy in the modern era, and then take an example of location tracking. So I think the essential phenomenon that we are all experiencing now is that it is easier than it ever has been to collect, record, store, share, and analyze information about each and every one of us. I think one useful example of this is to contrast email to postal mail. Postal mail was extremely difficult to go through if you were the government, right? People might save very pressing correspondence for periods of time, usually inside their housings, but you wouldn't save, for example, every postcard your dentist ever sent you reminding you about your 6-month appointment, right? That was simply not something that was going to happen. Contrast your Gmail account. Out of curiosity, how many of you use Gmail? How many of you used Gmail 5 years ago? That's a fair number of us, right? So Gmail and Google know more about my last 5 years than I can even remember myself. If I wanted to know where I was having dinner on a Friday night in 2007, I would do a much better job to look in my Gmail than I would be to try to remember that, right? The point is that email is easy to store and to search through. Postal mail was much more difficult. And that phenomenon is true for everything we may choose to say in that communications medium, but is also true across the board for everywhere we go and abroad many other areas of human endeavor, including our sensitive information such as our medical records. And the goal the ACLU is really trying to advance is that the constitutional values we are protecting should be stable. And so to continue with the correspondence example, just as the government has traditionally needed to get a warrant based on probable cause to search through a letter you sent through the postal mail, so too, in our view, should the government need to get a warrant based on probable cause to look at the contents of someone's email. That, unfortunately, is not the position advocated by the U.S. government. The government has, for example, taken the position that because your email is stored by a third party, and to continue with the example, in this case, Google, that you have voluntarily disclosed that correspondence to someone else and have therefore forfeited your privacy interest in it. And that's not a position the ACLU would share, but that shows some of the dynamic that's at work here. But I think the most interesting area right now when it comes to privacy, technology, and security is actually location tracking. We're experiencing, I think, a constitutional moment when it comes to location tracking. To back up briefly and talk about some of the technology at play, and I'm not going to mention drones because others are speaking about that, there are a broad range of ways in which each of our movements is commonly recorded every day. The more primitive way of doing this would be to attach a GPS device to the bottom of someone's car, right? You used to, when you wanted to follow someone, it was an expensive endeavor. You needed a team of officers working around the clock in order to track someone. Today, any police officer can, from the comfort of a station house, sit and track someone's movement looking at a laptop by attaching a GPS to the bottom of the car. Incidentally, if you have something like an onboard navigation system pre-installed in your car, it's not necessarily even necessary to go through the effort of physically attaching a device to your car to do the tracking. It's a matter of compelling the provider of that OnStar or whatever navigation system to turn over the records to the government. GPS is one example. Cell phone tracking is another common example. When I started talking about this years ago, I would ask for a show of hands how many people have a cell phone, right? But today that's basically redundant. Essentially everyone does. There may be a few holdouts out there, and as people are increasingly aware, your cell phone registers its location with your cell phone network approximately every 7 seconds. And so if your cell phone company were so inclined or compelled to do so by the government, it could produce a record that was very precise about where you have been in the past, or where you are going in real time. Incidentally, cell phone companies also store your historical location records. AT&T, for example, based on a document disclosed by the Department of Justice, seems to have location records on its customers going back to July of 2008. The net effect may be that between AT&T and Gmail, our lives are an open book. The reason I said that there is a constitutional moment in location tracking these days is because of a recent Supreme Court case called United States versus Jones. I want to make sure I'm pitching this to the right level, and so I'm curious, how many of you are already familiar with the Jones decision? Okay, about half. So I'll just mention this briefly, right? The facts of the case involve an individual whose location was tracked with a GPS device. The government attached the GPS device to a car that he drove. His movements were tracked for 28 days. And the warrant that the government had got was invalid, so it was de facto a warrantless search. in the course of a criminal trial, the individual filed a motion to suppress the evidence that had been gathered through the GPS tracking. The case went up to the Supreme Court, and a unanimous Supreme Court held that tracking someone's movement by attaching a GPS device to their car is a search under the Fourth Amendment. I had the privilege to be able to attend that argument, and the moment that I think anyone who was in the court would remember was when Chief Justice Roberts leaned over the bench and the government had presented what I think even he regarded as an extreme argument that there was simply no that it simply didn't implicate the Constitution at all for the government to attach a GPS device to someone's car, was when he said, to the government lawyer, does that mean that you could attach a GPS device to the car of any of the justices with there being no constitutional scrutiny, right? And of course the answer, the unfortunate and inconvenient answer for the government attorney was yes, that's exactly the implication of the argument. What the Jones decision will ultimately mean remains to be seen. The majority opinion written by Justice Scalia held that when you attach a GPS device to someone's car, you have committed a trespass, and therefore it is a search under the Fourth Amendment. It didn't rule whether it was the type of search that required a warrant based on probable cause as opposed to some lesser standard, such as a reasonable belief on behalf of the law enforcement agent that the search would turn up evidence of wrongdoing. That's an important distinction because a warrant requires going to a judge, which I think is the strongest protection there is to make sure that a law enforcement agent has had to carefully think through how the evidence he or she seeks to gather is related to the crime that's being investigated. So that battle is still playing out in the court system. I think the biggest question on location tracking right now actually has to do with cell phone tracking because virtually all of us have them. And the rationale put forth by the majority in Jones doesn't necessarily extend to cell phone tracking because the case in Jones involved the physical trespass of going onto someone's property and attaching a GPS device. When you want to track a cell phone, you don't need to trespass. You just need to go to the cell phone company and get an order requiring the company to disclose the records of someone's movements. There was a concurring opinion authored by Justice Alito in the Jones case in which he was, I think, surprisingly dismissive of the trespass rationale put forth by Justice Scalia and essentially said the issue here is not that there's been a trespass. The issue is that you're engaged in prolonged location tracking. You're getting a complete record of someone's movements over time. And so there is some thought that, at least based on that rationale, that tracking someone through their cell phone for a prolonged period of time, query what prolonged will ultimately end up meaning, will also require a warrant based on probable cause. But I like talking about location tracking because I think it's a good example of what's going on. Technology has radically changed. The Supreme Court used to be clear that if law enforcement agents wanted to physically follow someone, there was no Fourth Amendment issue with that, right? Technology has changed, bringing down dramatically the cost of engaging in location tracking. And the question is, will the Supreme Court, as the barrier of cost to using this particular technique falls, will the Supreme Court recognize legal barriers to ensure that this type of surveillance only occurs under rigorous standards? And I think that's a question that we'll all see playing out in the future. I've talked about cell phone tracking. I'll just mention one other interesting example. I often feel like when you're engaging in advocacy for privacy, dealing with new technologies, that it's sort of an elaborate game of whack-a-mole, right? You may have legal standards imposed for one particular technology, for example, GPS tracking, but then a new technology will appear. And so I want to just talk about automatic license plate readers for a second. These are essentially cameras, which are increasingly cheap. They can cost $5,000 or $10,000. That can be attached either to a police car or to a stationary object, such as an overpass, right? And they would take pictures of passing vehicles. Those pictures, at first the ACLU wasn't particularly concerned about license plate readers, right? If the police want to use this technology, for example, to locate stolen vehicles or people for whom there is an arrest warrant, the ACLU has no objection to that. But what is increasingly happening as the cost of storage for electronic information has decreased is that records from license plate readers, which consist incidentally of a photograph of the license plate, a machine-readable text of the actual number on on the plate, in addition to the latitude and longitude at which the image was taken. Those records, which used to be stored for a short amount of time, are now increasingly being kept indefinitely. And license plate readers, which again used to be relatively expensive, are proliferating dramatically as they become cheaper and cheaper. There was an article in the New York Times just last week indicating that the NYPD alone has 398, I think was the number, license plate readers. But the ACLU last summer, 38 ACLU affiliates in states around the country filed over 500 Public Records Act requests with police departments large and small to understand about their acquisition of license plate readers. And it turns out you don't have to be in New York in order for your license plate to be picked up by such a reader. Even small towns now have these, largely perpetuated by grants from federal agencies such as the Department of Homeland Security. So, I think the location tracking issue and how much privacy Americans will have when they leave their houses is one that we are all going to be grappling with for years to come, and I'll stop there.
Great, thank you so much. Now we're going to hear from Colonel Don Zoldi and about domestic use of drones in the Air Force.
Thank you so much, Professor Hu. And I also wanted to thank General Dunlap for your leadership here at Duke and this Lens Conference. I attended last year, and this is greatly expanded, and it's a phenomenal conference, so thank you so much. When one looks at the composition of this panel, at first you might think, wow, there's going to be some wildly divergent views here, right? You've got the Air Force, you've got the ACLU, you've got academia on the subject of privacy, technology, and security. But what I would submit to you is that at the heart of it, our interest is the same, and that is protecting and upholding the Constitution. And it is so from that premise that I'm going to discuss the domestic use of remotely piloted aircraft by the United States Air Force in the United States. Because specifically, I would like to dispel the notion that some may have that the fine men and women who wear this uniform are out there controlling remotely piloted aircraft or RPAs to hover over people's backyards and spy on Americans, because nothing could be farther from the truth. And so what I'm going to talk to you about today is that not only is, of course, the law fundamental to our nation, it's fundamental to our RPA operations. I'm going to walk you through that. Before I begin, of course, what I have to say is the obligatory caveat. You got it on the administrative slide, but although I'm here wearing my uniform, of course, my views are my own. They do not represent those of the Department of Defense, the United States Air Force, or Air Combat Command. Now, that said, of course, my views are colored by my experience. So I want to just take a minute to divert and talk a little bit about kind of how Air Combat Command fits into the big picture. I had some conversations last night and led me to believe that perhaps I need to explain how the military works to understand how our domestic operations occur. And so the Goldwater-Nichols Act created combatant commands, and you're going to hear from General Mattis tonight, from those of you who will be attending the dinner. He's the four-star commander of what we call a functional geographical combatant command, U.S. Central Command. And they're basically the warfighting commands. And you have several geographical commands like EUCOM, AFRICOM, right, NORTHCOM in charge of Homeland Defense. And then you also have functional commands such as United States Transportation Command and United States Special Operations Command. So those are your geographic and those are your combatant commands. And so when you look at the services then, the Army, Navy, Air Force, Marines, and you heard from the Coast Guard as well today, the role of the services really, under 10 United States Code 8013 Bravo, is to organize, train, and equip forces to provide to those combatant commands. Now, within the Air Force, Air Combat Command's role is to organize, train, and commit and equip the combat air forces then to provide to the combatant commands. And so that's the perspective that I bring to this particular topic from Air Combat Command. And so it's for that reason that I'm not going to talk about the kinetic operations overseas. I know there's a lot of interest in that right now, particularly with the DOJ white paper that has recently come out. So that is not something I'm going to talk about during my speech right now. However, if that's something you'd like to talk about offline, I've read the paper, I'm familiar with those operations, and I'm happy to engage in that capacity. The third thing I wanted to clarify was terminology, because what you'll hear most people calling these aircraft are drones. And you're going to hear me calling them remotely piloted aircraft, or RPAs. Yeah, because words matter. And I'm going to give a little history lesson. Airmen have been flying unmanned aerial vehicles since the 1800s. First it was balloons. And then in World War I and World War II, at some point they actually started flying the planes, and the pilots would jump out of them and they'd use them to target things. Unmanned aerial vehicles. It was really in the 1960s when Air Force pilot Gary Francis Powers was shot down or was crashed in the USSR that an unmanned intelligence, surveillance, and reconnaissance vehicle, ISR, became a big priority. And in fact, in Vietnam in the 1960s, numerous, I think hundreds of sorties were flown by what they called drones. And they called them drones because they were very simple vehicles. They would fly around in circles, take pictures, and when they ran out of gas, they would land. That's why they called them drones. And I think there's also another tie because they actually were fire bees, and drones, if you look in the dictionary, the first definition is they're the ones that pollinate the queen, right? So maybe there's a connection there, but that's what drones, that's why they called them drones. Now, obviously, we've talked about technology come a long way between the 1960s and now with regards to the capabilities that these particular assets bring to the table. And it was in actually as recent as 2010 that the Air Force did two things. First, they designated RPA pilots as rated pilots. That means they have career aviation status. That was a big step in the aviation world. And the second thing they did is they formalized training for RPA pilots as well. And that's when they changed the terminology to remotely piloted aircraft. So what's important about that term, again, it just maybe seems like semantics, but the point is these are not simply unmanned. These are actually aircraft that are piloted, albeit remotely, by trained aviators. And that's an important point. And finally, of course, I would be remiss not to acknowledge that right now there's a huge debate going on, and I know, Catherine, your organization is the forefront of this, as to how commercial and civilian RPAs will be assimilated. So there's the 2012 Federal Aviation Administration, or FAA, Modernization and Reformation Act that basically charges the FAA with assimilating civilian commercial actually all RPAs, into the national airspace with a deadline of 2015. That's a pretty big deal. And what hasn't happened yet is kind of the regulatory exercise of what are the rules for this. And so in the absence of that, what you see now are a whole bunch of states jumping into the fray. And no federal endorsement implied or intended, of course, but I'm going to give a plug for the ACLU's website, Catherine's blog. You have actually a really good chart of the number of states that have proposed legislation to deal with the RPA issue and kind of the status of where those are. And that's pretty significant. Now, the majority of these proposed statutes at the state level are requiring judicial warrants before RPAs can be used for law enforcement purposes. And that's actually a really excellent point of contrast here. I think you were all here earlier when Professor Sulmazy said that the Coast Guard is the only military organization with law enforcement powers. That's kind of a foot stomp because the rest of us, the Air Force, the Navy, the Marines, the Army, we don't do law enforcement. And so that's a significant difference from what a lot of these statutes are focused on. So that's a good point of contrast. In fact, we also heard a little bit about the Posse Comitatus Act earlier, and that basically forbids us from, quote unquote, enforcing the laws. Two exceptions, unless authorized by Congress or in compliance with the Constitution. And those will become important a little bit later. So basically, what does then the Air Force do? When do we fly remotely piloted aircraft in the United States? Why would we do that domestically? Two reasons. First is for training, and that training is critical for our pilots, just as it is for manned aircraft. What I would say is training is airframe agnostic, right? You want your pilots, regardless of what it is they're flying, to be able to do it well. And so that's one thing we do. And the other thing we do is support to civilian authorities, what we call DISCA, or Defense Support for the Civil Authorities. And those are primarily in emergency and unique situations. So those are the two key areas in the United States where we're using RPAs. Now, all of these missions have their own specific approval authorities, guidelines, and limitations. And they are subject to regulations, laws, and all of these things balance governmental interests with privacy protections. And the other thing about these rules, and I'm going to talk about them in a second here, is for the military, compliance is not optional. Okay, they're lawful orders, and so there you have it. So from all of these rules, and by the way, for a lot of my career, I've been a litigator, and really huge thing, right? When you're in trial, you have to have demonstrative evidence because picture paints 1,000 words. Well, I don't have slides, but I did bring my binders, okay? And so you see these here. These binders here are not really all of the rules that I'm talking about because the rules are dense on this topic. These are some. And for those that might want to FOIA them, what I would say to that is, guess what? They're all available publicly. Not in my pretty binders, of course. I'm not giving those up. But yes, DoD Pub's website, DoD publications, Air Force publications, Chairman Joint Chief Staff publications, National Guard publications. They are all publicly available. And so the rules that I'm going to refer to today are all available to the public. So if you want to talk about transparency, there you have it. So there's three, out of all of these rules, three key takeaways that, if there's anything you remember from my couple of minutes with you here today is this. First of all, RPA domestic operations are conducted, they are authorized by law is the first point. Secondly, they are conducted in compliance with the law. And thirdly, that there is actually an oversight regime that oversees whether or not they are complying, and that's an internal and external oversight mechanism. And I'm going to talk all about that today. So if there was kind of an overarching theme, also it would be that capability does not equate to authority. What does that mean? Okay, just because a commander may have a remotely piloted aircraft on his base doesn't give him carte blanche to use it for whatever purpose that he so chooses. Okay, so the analogy is this. Just because you own a car doesn't mean you have a license to drive it. What do you have to do, right? You have to study, you have to take a test, you have to get state certified, and then after you do all that, there's rules of the road, and you must follow them, or there's ramifications. And so that's the analogy we have here. So for what I want to talk first about is the authority to act, because like I said, there's a lot of regulations, and you're going to say, oh, regulations, well, those are just DoD policies, right? You guys can make up whatever rules you want. Not so much true. Okay, all of these are grounded in law, and it starts with the National Security Act of 1947, and then through the Executive Order 12333, and the DoD directives, and the Air Force instructions, and each service has their own regulations on down that implement all of those. Okay, so that's what we're talking about, and what they do is they explain not only who the approval authority is for the various missions, but also then what are the parameters, what are the limitations, what can you view, how long can you retain it, who can you disseminate it to. That's what these rules are all about. Now, when you talk about approval authorities, what I'm talking about there is who actually gets to approve that mission. Like I said, just because it's on the base doesn't mean that wing commander has carte blanche to fly that thing for any purpose that he or she so chooses. So what you'll find as you drill down in these regulations is something quite remarkable, that for the majority of domestic operations, the approval authority is the Secretary of Defense himself. Now, that's kind of a big deal because if you think about, if you don't know a lot about the military, let me just explain for a second. It's not like the wing commander at Holloman Air Force Base has a red phone and he calls up, the Secretary of Defense and says, hey, this is what I'd like to do. There's at least 6 echelons in between that commander and the Secretary of Defense. So I'll very briefly walk you through that. You've got your wing level. In the Air Force, you've got your numbered Air Force level. You've got your major command level, which is what Air Combat Command is, chaired or commanded by a 4-star general. Then you have your headquarters air staff, and you have Secretary of the Air Force as well. And you're going to hear from SAF GC, the General Counsel of the Secretary of the Air Force tomorrow. You've got your joint staff, and then you've got your DoD General Counsel before it gets up to the Secretary of Defense. And oh, by the way, every single one of those staffs has lawyers embedded in them, and they're looking at these issues. And the other thing I would say is every single one of these directives and regulations, before they are actually finalized and published, they get vetted. And they get vetted broadly. And there's a lot of lawyers looking at them, not only within the DoD, but actually outside of the DoD. If someone has an interest, for example, Department of Justice would have a big interest in what we're saying about intelligence oversight. And so they're going to be reviewing, and their lawyers are going to be reviewing these regulations as well. So, but let's put this in context, because I talk about these missions, and so defense supports civil authorities, temporary support. We've got law enforcement support, and you're thinking, wait a minute, she just said posse comitatus. They don't do law enforcement. Right, we don't do law enforcement, but we can do support to law enforcement if authorized by Congress or consistent with the Constitution. And we have a directive on that. If you want to see it during a break, I'm happy to show you. 5525.5. Counter-drug, that's another one. There's actually statutory authorization for militaries to do limited counter-drug operations. 10 U.S.C. 10,004A. And civil search and rescue is another big one. And for all of these, the ones I'm talking about right there, those are the ones that require Secretary of Defense approval to do that in the United States. Let's put it in context. How often are we doing these things? How often are we saving lost hikers with RPAs? I asked the operators before I came here, because I am one that prepares. And they told me that for all of calendar year 2012, according to, again, our ops community at Air Combat Command, 0.01% of all RPA flight hours were in support of DISCA. That's it. So this is not a big slice of the pie. And when I asked, so training hours, what are we talking about when we're talking about training? They said it varies depending on the actual aircraft, between 16 and 13% of, so most of these aircraft are actually being employed overseas. They're not all hovering around in the United States. And when they are here, they are doing SecDef missions or training. So let's talk about training for a second. Most cases of training is conducted over DoD restricted airspace, federal installations, and there are rules on this, right? So key rule is that during training, it is prohibited to conduct non-consensual surveillance on U.S. persons. There you have it. And so that kind of gets to point number 2, which is that our operations are conducted in accordance with the law. And the law that's going to apply to this, these kind of operations, whether it's training on our range, whether it's another mission, DISCA or other, are the intelligence oversight rules that I mentioned earlier. So you're talking Executive Order 12333, DoD Directive 5240.01, and other regulations such as that. And the bottom line here is that the Department of Defense, Air Force, all of us, right, we don't domestically collect information on non-DoD affiliated persons or individually identifiable U.S. persons or organizations using airborne domestic imagery unless some really specific conditions are met. And again, we're talking SecDef approval. So what's intelligence oversight? Why do you care about it? Why does it apply to RPA at all? Okay, it applies to RPA because RPA are an ISR asset, intelligence asset. And as such, those rules apply. And what the intelligence oversight rules do is they govern collection, the retention, and dissemination. And I'm not going to get into all the details because, frankly, the Army puts on a really great one-week-long course on this, and I just can't do it in 5 seconds. But suffice it to say, there are limitations. And what I will also tell you is that, in fact, the Air Force has I would submit, and this is, again, my personal view, taking a much broader view of intelligence oversight than even the executive order or the DoD directive. Because in the Air Force instruction, 14104, that deals with intelligence oversight, it applies intelligence oversight to non-intelligence organizations that perform intelligence-related, air quotes, activities that could, foot stomping the word, could collect, analyze, process, retain information on U.S. persons. So that's pretty broad, and that's a pretty broad swath of folks that and activities that these rules are going to apply to. And I don't want to run over my time here, so I'm going to make my last point, which is oversight. Okay, so we have authority for the mission, we have rules that apply to the mission, and then we have oversight to make sure that all of that was complied with. And that is starts from the local commander, who is intimately involved in these operations, all the way through really the President's Intelligence Advisory Board, through what we call ATSDIO, the Assistant Secretary of Defense for Intelligence and Oversight, who reports to the Secretary of Defense quarterly on activities. The bottom line, if there is and this is another important word, a possible violation of intelligence oversight rules, policies, regulations, that's supposed to be reported. Not that we know what happened, but we possibly did it, or we possibly know about it. And it gets reported up to the highest levels of government, and not only that, it then gets also reported out to Congress as well. So I just wanted to explain this, and I hope that you've come away with a better understanding of how we conduct RPA operations domestically. And I think this is a great quote from the President when he gave his Nobel speech. He said, "We lose ourselves when we compromise the very ideals that we fight to defend, and we honor ideals by upholding them." And what I would submit to you is that for domestic RPA operations, that we're honoring those ideals by complying with the law and policy, and also by the watchful oversight that ensures we do that. So that's all I have for now. Thank you.
Thank you so much. Now we're going to turn it over to Professor Nita Farahany.
Thank you. So thank you for being here today at Duke Law School. Thank you to Charlie, my colleague, for inviting me to talk with you. It's a great honor to be able to talk with you about an area that I'm quite passionate about and that I hope you don't know too much about and that I can enlighten you a bit about. And that is thinking about emerging technologies, particularly neuroscience, and its implication for our concepts of privacy and civil liberties, in particular thinking about the Fourth Amendment. And then I'm going to shift gears at the end of my talk just to give you a little bit of a flavor of a field that's emerging called neurosecurity. And so you'll see some of the applications of the technologies I'm talking about in the first part to think about the ways in which neuroscience is being integrated into military operations. So to begin with, I just want to tell you that most of my work looks at criminal law and criminal procedure. And it thinks about how are those fields going to deal with emerging technologies from genetics and neuroscience. So for example, how do courts deal with Fourth Amendment claims about unreasonable searches and seizures when the government collects DNA that's been shed on your water glass that you leave behind, hair clippings. I had my hair cut this morning. I'm sure it looks lovely, but I left plenty of DNA behind when I did so, or through blood that's left at a crime scene. And how courts are dealing with this question, which is to largely say you have no privacy interest in any of that, might tell us a little bit about how the government is going to deal with the second area that's starting to emerge, which is what about when we can start using investigative techniques to detect whether or not you're lying, what you're thinking, or more provocatively, what visual imagery or memories that you have stored in your brain, assuming that you can actually remember things and, you might have incentives to start forgetting after this talk. So, where you're sitting right now looking at a panel of all women, you may have this very question in your head, right? Which is, what exactly do women want? I have no idea. But how many of you have seen this movie, What Women Want. It's a great movie. It's very funny. I think that there's a What Women Want 2 now, which is great because you can never know the answer to that question, so they can just keep that franchise up. But what's nice about this movie is what happens in the beginning of the movie, and this won't spoil it for those of you who haven't seen it, is Mel Gibson falls into the bathtub with his hairdryer. And for any of you who, know Basic 101, that's a bad idea. You do not want your hairdryer plugged in and going into a full bathtub when that happens. Why is that? Because you can be electrocuted. Well, lo and behold, for Mel Gibson, that isn't quite what happened. He was electrocuted, but he had this wonderful new gift when he woke up in the morning, which is he could now hear women when they were thinking. Just women, right? Just the fairer sex. But he could hear women when they were thinking, and he used that to seek to undermine one of his fellow ad executives. Well, what if we got to that place in the world? What if we got to the place in the world where we could hear what other people are thinking? There was a great new study that came out this week from Duke where they set up rats continents apart that were able to communicate telepathically with each other given some technology that they actually used. That's extraordinary. Can we do that? We might be able to. We might be able to, and brain-machine interface technology might make that possible. Well, this is all tremendous, and we should be very excited. Neuroscience is changing the world, but it is also changing our fundamental concepts of privacy. We're going to have to think totally differently about this stuff because if you think your email is private, I bet you think what's happening in your head is even more so, and I bet you'd be much more concerned if people looked in there than if they looked in your email. All right, so just to give you just a little context, we've already talked about the Fourth Amendment. Ms. Crump gave you a great overview of some of the issues, but I want you to keep two distinct questions in your mind from the Fourth Amendment, right? The first one is, what is a search? Because the court deals with these questions, and courts deal with these questions as a two-step process. First, has a search occurred? And believe it or not, while that might seem obvious to all of us based on that word, that is not the way that courts use that word, right? Search means a particular thing in a Fourth Amendment context, which is, was there an intrusion upon a legally cognizable interest that you actually have? And for the most part, that has only been treated as property interest. If you have private property, real private property that has been intruded upon, then a search has occurred. And if real private property has not been intruded upon, no search has occurred. So we don't have to get to the second question, which is, if a search occurred, is it a reasonable search? Okay. The neuroscience applications I'm going to talk to you about, this matters for you to keep in mind because you need to get past step one before we can ever ask step two. You have to prove that a search has actually occurred before we ever worry about whether or not that search is reasonable or unreasonable. And we talked about property being the kind of paradigmatic case. So Fourth Amendment protections arose from concerns about ransacking homes and indiscriminate searches of private properties. And the way that all of this has ended up being implicated, we'll talk about, which is the primary interest in privacy that we protect in this country, whether it's through the tort invasion of privacy doctrine, Fourth Amendment privacy interest, or statutory privacy, is a physical intrusion into your space. Okay, a physical intrusion into your space. We are in the age and in the era where we care far less about physical intrusion into our space, and we care far more about informational privacy, right? And real property law doesn't think about information, but there is an area of law that does think about information, right? What's that area of law? Intellectual property law, right? Intellectual property law disaggregates the substantive thing that you have, like the physical CD we care far less about than the information that is stored within. But all of our privacy protections really turn on real privacy law, not on informational privacy law. And there's an article that I will refer to throughout this, which is Searching Secrets. You can have a copy of it outside. I talk about how informational privacy maybe needs to turn to intellectual property law instead of real property law, because real property law doesn't tell us anything about this area that we're interested in. But one thing for us to understand is anything you throw away, right, you've abandoned and you have no interest in it. So you can't trespass upon that interest. But what about the things what about when those things you throw away aren't really the soda can? What if the thing you're throwing away is your DNA, right? So I throw away my cup, it has my DNA on it, and courts have said, well, you've trashed your DNA. I have not trashed my DNA, at least not intentionally, right? And intellectual property law thinks about that. If I lose a CD that has original authorship, like song on it, you wouldn't think that I've lost all rights to that song just because I lost it or threw it away. So should I have some interest in my DNA? Maybe. But we'd have to fundamentally rethink how we treat these issues. I haven't thrown away my DNA when I throw away a cup, even if I've thrown away a copy of it unintentionally because there's no way to safeguard that information. All right, so we'll skip ahead to this, which is what I've said is, again, the thing that we are very comfortable dealing with right now is intrusion upon your seclusion, right? If I hide something behind a door and you break down that door, that you have clear protections against. But what about this, right? You probably went through an airport to get here. Hopefully that doesn't look like you, but if it is, I apologize, right? So you went through an airport to get here, for this conference, and you no doubt went through some different detection technology. No physical intrusion upon your space actually occurred here, right? So what is it that people are concerned about when they go through an airport detector? It's really not a physical intrusion upon their space. It's revealing things that you can't see with the naked eye, right? It's information and visual information. What about in your computer? I assure you that if any of you open up my computer, like go inside of it and look at the little bits and bolts inside, I don't care. But if you take my computer and you read all the files that I have in there, I care a lot more. And if you go into my brain, I'm going to care a lot more about that. Well, can you go into my brain? If you can, the thing that you're going to find is that you are intruding upon my secrecy, not my seclusion. Now, a little bit upon my seclusion because, if you go inside my brain, you got to do something invasive to get there, except not necessarily. There are a lot of techniques and technologies now that enable you to never physically go inside my brain. Functional magnetic resonance imaging, you go into a scanner, and we're able to look into your brain and see the functioning of your brain, and then we're able to use the information that we see through blood oxygenation levels in your brain based on the patterns of activity in your brain and sophisticated computer algorithms to decode what that means. So without you doing anything other than lying still, I can get that information. Well, can we make that portable? Not really fMRI, that's going to be hard. But there's another technology called near-infrared imaging, functional near-infrared imaging. I can have a little headband on your head, and I can use just an infrared light, and based on the diffusion of light that goes through your head at different tissue depths, I can actually do the same thing. I can deconstruct a lot of information in your head. Well, what kind of information? We'll talk about that. Let's do that in the context of a little hypothetical story, okay? So this little hypothetical story, these little boxes are going to mean something to you in a minute, I hope. We're going to do a thought experiment, and because it's a thought experiment, don't take me too seriously about all of the scientific technology I'm going to tell you about. Okay? When I say don't take me too seriously, I mean we're not doing it today in this way. But all of it is based on scientific papers about the technologies which are available to use in these particular ways. But really don't be terrified yet. It's not out there yet. All right. So suppose a police officer stopped a motorist, and he believes that motorist is intoxicated. If the motorist chooses to remain silent, what information could the policeman glean during a brief and physically unobtrusive stop of that motorist? Okay, so the person's just silent, uncooperative, we want to get some information. Well, the police could use a mobile biometric brain scanner to gain precise and reliable information about the motorist's identity. You have a specific neural fingerprint, which is much more precise than any other neural fingerprint you have, and we can figure out who that person is using biometric brain information. If the motorist is in fact drunk or intoxicated in any way, then the police could also bypass the need to have the motorist perform a breathalyzer test to assess his intoxication by directly measuring his brain's metabolism of glucose. Because your brain is metabolizing glucose, and we can see that through a scanner, especially when they're remote. Third, rather than asking the motorist whether he'd been drinking, the police could simply probe his brain for episodic memories of the evening. Okay, deconstruct the visual imagery in his head to see where was he? What are the memories he has stored in there? Or simple recognition memory. And I'm going to dive into each of these a little bit more deeply to give you a sense of what each of them are. Most directly would be if the police officer could simply use neuroimaging and pattern recognition to decode the contemporaneous, unconscious, and unspoken thoughts of the motorist. Well, some of you might be thinking, well, what about the Fifth Amendment right against self-incrimination? That's a good question, and the answer is it's not going to help this motorist, particularly because he's not in a criminal trial. But besides that, even if he was in a criminal trial, it still won't help him because the privilege against self-incrimination doesn't apply to physical, real evidence. It applies to spoken testimonial evidence, and all of this is just the motorist sitting there silent, not doing anything at all. So let's start with the first category. So the police officer is interested in using biometric information. Identifying information means things like a person's name, their birth date, their weight, their height, their clothing, their shoe size, and every court that has dealt with a question of whether or not a person has a privacy interest in their identifying information has almost uniformly said no. Okay, so new neuroscience enables far more specific ways to identify individuals. The Oak Ridge National Laboratory, managed by the Department of Energy, their researchers have developed a novel method of identifying and authenticating individuals using brainwave data that is uniquely formed based on your thought processes. The brainwaves are sampled using EEG, electroencephalograph equipment, and processed using phase-based distribution to compare the digital signature data to databases. Well, does this sound like anything that you've heard of before? Sure, like DNA, right? DNA has data banks. We take a sample. Well, you can sample individuals' brains, compare it to a database, and now we've got a uniform national database of your brainwaves and your thought processes. That's fantastic. It's exciting, but it does change the way we think about privacy. Okay, but that's just the first step because we can also go to your automatic processing of information in the brain. So I'll give you some analogies to automatic in a moment, but this is automatically generated information. So it means actions and reactions that occur with very little conscious control by you. So when you drink alcohol, the glucose metabolism in your brain will change, as I mentioned, and measuring that glucose impairment tells us about the functioning of your brain and the degree of impairment that you're suffering from. And in such a test, which requires no conscious processing of information whatsoever, is that a Fourth Amendment search? What privacy interest do you have that's been implicated? What intrusion upon your seclusion has occurred? What secrecy interest, if any, when there's no conscious processing of information, might be implicated by such a search? Probably none. But if you think about the analogies, what is automatically generated information, courts that have addressed this category have found that there's only a privacy interest in seclusion, but not in other information, like the routing information in your email headers. That's all automatically generated. You don't intentionally create those routing informations, or the log of account activity in your email, or, as was mentioned earlier, your GPS tracking and triangulation. It's all just automatically generated information. So what interest, if any, beyond seclusion, which is the trespass interest that Ms. Crump talked about earlier, what interest in any of secrecy do you have? All right, neuroscience gives us yet another category that, because of the method by which it is obtained, is potentially quite troubling for civil liberties and privacy. What you're looking at up here is an extraordinary study by a scientist named Jack Gallant at UC Berkeley. And he has the most sophisticated algorithms out there right now to decode what's happening in the brain. What you see on the left is an image that was presented to an individual who was in an fMRI scanner. What you see on the right is, based on blood oxygenation level only, reconstruction of the visual imagery in the brain. Now, this image is extraordinary, but maybe not that extraordinary to you because you think that's pretty fuzzy. You might find it surprising that I think this is so amazing. Well, you should think it's pretty extraordinary because only looking at blood oxygenation level in the brain, they were able to reconstruct this, and this is only looking at the first 3 levels of your visual cortex. As you go back to 4, 5, and 6, which are the further layers of your visual cortex, blurring, color, and the kind of sharpness of the image are what are encoded for, and they just wanted to do a proof of concept here, which is just looking at your brain, they can deconstruct the visual imagery. They have a new study that's coming out this month where they read people's stories. And then they tried to figure out, based on how your brain processed the stories that you heard, could they reconstruct the language in your brain? And you know what the answer is? The answer is yes. They can figure out, not just from your auditory cortex, but also when you think of thoughts and you report what those thoughts are, they can deconstruct those thoughts from blood oxygenation levels alone. And blood oxygenation level is a really primitive technology relative to some of the newer technologies that are out there. That's extraordinary stuff. That's really extraordinary stuff. And it's really not physically intrusive or invasive at all, which means, what does privacy look like in the world where these neurotechnologies can be used to try to figure out what the episodic memory is that the person has in their brain, or to decode the thoughts that are in their brain? All right, I only have 3 minutes left here, so I'm going to spend just a couple of minutes just telling you about a couple of neurosecurity issues. Not that these all weren't already neurosecurity issues, but just telling you about a couple of other things for our conversation and Q&A. Okay, so there's 3 main categories in neurosecurity that are happening right now. The first one is the use of neuropsychopharmaceuticals. Neuropsychopharmaceuticals can be used to enhance soldiers, either cognitively or for other reasons, or to target other people. And I'm going to give you a couple of examples of those, but not these other 2 categories. The second category is brain-machine interface technology. Really amazing stuff. DARPA has invested tremendous amounts of money in this. The Army has invested tremendous amounts of money in this. It has extraordinary possibilities both for things like prosthetic devices, being able to connect the brain to an arm and enable a person through their thoughts alone to move that arm and to experience sensation, but also has pretty extraordinary capabilities to have things like robo-rats in the fields who are able to detonate mines or to go out and scope out things in a field that you wouldn't want to send a human into. And the last is, really part of neuropsychopharmaceuticals is reducing or eliminating PTSD. There's extraordinary drugs out there that are commonplace drugs like propranolol. Some of you may even be on propranolol, which is a beta blocker. And that beta blocker can prevent the consolidation of the fear associated with a memory if it's taken within the first 24 hours after a traumatic event, which can prevent the consolidation or a person suffering from PTSD altogether. Now, there's mixed results on that. And some people have seen remarkable results and some people haven't. But the fact is, we're looking to see ways that we can target the consolidation of specific memories, interfere with it to prevent traumatic events from resulting in long-term implications. So I'm just going to focus on this first one for a moment here in my remaining time to tell you about a couple of cool neuropharmaceuticals that should be on your radar. So the first one is enhancing soldiers. This one right here, this picture is a vision in 2030 of what a soldier might look like. And when you see the picture up close, you'll see lots of cool little, devices that are under investigation. But one of them is enhancing the cognitive capabilities of individuals. And those cognitive capabilities could be simple things like having a person be more wakeful. And there are some pretty great drugs out there to help a person that are far better than caffeine. How many people have experienced jitters from caffeine? Okay, and if I told you that there was a drug that is already FDA approved called modafinil, which had no jittery side effects but would make you feel fantastic all day long, would you want to write that name down and go out and get it? You should. Modafinil. It's great stuff. It has some side effects, but they're pretty minimal. It's a very clean profile, and the Air Force extensively tested this in the 1990s for Air Force pilots, and they found that not only is it fantastic for wakefulness, it also significantly improves cognitive performance. So it improves cognitive performance IQ and not just the ability of a person to stay awake. But there are other ones too, some of which we can talk about in the Q&A. And the last one is just the targeting of others. Now, what do I mean by this? So we can modify other people's behavior by giving them drugs. Okay, we've heard about truth serums and use of those types of drugs in things like interrogations. What if I could just make you trust me a little bit more? Right? If you trusted me, would you be willing to cooperate with me far more than if you didn't trust me? Sure. And there's a great thing that you all have that is part of your body called oxytocin. How many people know about oxytocin? Good, quite a few of you. Oxytocin's great. You can get it by hugging someone. You can get it by hugging your dog. You can get it by hugging your spouse. You can get it by hugging me. It's true. I'm here to free hugs afterwards for oxytocin. But if you hold somebody for 20 seconds, you can have oxytocin released. And what does that do? It promotes bonding between individuals. It decreases your inhibitions. It increases your likelihood to trust and cooperate with that person. Well, it turns out we can bottle it. Anything that we can release in our brains, we can bottle as well. And we've bottled it, and we've put it into a nasal spray. It's necessary to be administered via nasal spray because in order to cross the blood-brain barrier, it needs to be in that form. So sniff it, you'll feel great, and so will the person you're interrogating. In fact, they've done some studies where they've looked to see whether or not it induces cooperation, and here's a cute one. So they put two people together. One person was the trustee, the other person is the investor. And the investor is given a set amount of money to begin with, $20. And they say, you can decide how much to transfer to the trustee, okay? When you transfer money to the trustee, it's instantly tripled. And then the trustee can give you back however much they want. Now, in order for it to be profitable for the investor, they have to trust that the trustee is going to give them some money back because the trustee can give them anything from zero to any portion of the tripled money that they give. So the person has to think, based on the probabilities and how much they trust that person, how likely are they to get a good return on their investment? Because they're guaranteed to walk away with $20 if they give the trustee nothing at all. So they did this study with oxytocin and without oxytocin. And what did they find? Every time that you gave oxytocin, it significantly increased the amount of money that the investor gave to the trustee. And if you gave it similarly to the trustee passed more money back to the investor. So it increased cooperation between individuals, and we've tested this in interrogation settings to see whether or not it might be a much better and less invasive or intrusive way of gaining cooperation in interrogation settings. Now, is that less intrusive? Is it less invasive? It's less intrusive if you compare it to physical intrusion upon your seclusion. But if the thing we care about is secrecy, if the thing we care about is safeguarding the ideas in your mind, our existing methods of protecting those things via civil liberties can't even come close to keeping up. So thank you, and I look forward to our discussion.
Great, yeah, that was exactly. Somebody just said that's one way to wake us up after lunch. So I would say for sure, our distinguished panel has done that at a minimum. So we've heard now Catherine Crump give us an overview of some of these emerging technologies, especially geolocational tracking and some of the challenges legally. We've heard from Colonel Don Zoldi about the checks and balances that are very reassuring in place with the Air Force's use of RPAs or drones. And now we've heard about the future of perhaps identification technologies and neuroscience and the Fourth Amendment from Professor Nita Farahany, and I think that opens a lot of rich field for discussion. We've left about 30 minutes for Q&A, and so would love to open it up to see what types of questions you have for our panelists.
Are we doing the microphone thing again? I think my question is probably best directed to Ms. Crump, although Professor Farahany, if you have any insight as well. I know there's currently a challenge to the collection of DNA incident to arrest, and largely on the theory that it facilitates investigation of crimes other than the crime for which the person is arrested. To the extent that that applies, that logic would apply similarly to collection of fingerprints incident to arrest. What's the ACLU's position on fingerprinting incident to arrest? And then what thoughts do you have on, is there a meaningful privacy distinction by which collecting fingerprints is okay, collecting DNA is not at that point in an investigation?
Do you want to jump in on the court case?
Sure. I mean, I'll start, and then we can find out if the ACLU has a difference. I'll say that the case for which there were oral arguments, I think this week on Monday, about the collection of DNA faces a couple of very serious hurdles. And the first one is this, right, which is we have basic identifying information that's been collected all the time from arrestees, including things like fingerprints. And is there any meaningful difference between DNA and that? Well, especially in this case, which presents the different. There's many ways in which we could collect DNA, right? One is I could collect DNA and then I could probe it and do a full sequencing of your DNA. And a full sequencing of your DNA would give me very precise information about who you are and potentially a lot of other information about you as well, right? Your predispositions, your preferences, even if you have short twitch muscle fibers or long twitch muscle fibers, so you're likely to be an Olympic athlete or not. What this case is about, though, is about just collecting a few loci, which we believe at this point are largely non-coding information. So I can pick random points in your DNA, and as long as those random points are unique between individuals, then I can match those random points, and that's really no different than your fingerprint, right? Because what I'm doing with a fingerprint is I'm picking random points on your finger, and I'm comparing it to random points, and when you have enough of those random points combined, the probability that it's anybody else is very low. So the big hurdle, I think, is starting with this question of, is it a search, right? And then second, is it an unreasonable search? Every court that's dealt with with these kind of coding questions about non-coding areas of the DNA have said it's really not a search. It's not an unreasonable search because even though there's the potential of doing something like sequencing all of your DNA, as long as they're not doing that, then we'll deal with that question in the case in which they do that. And I think that's what's going to happen here too, which is we're not yet actually collecting all of your DNA or sequencing all of your DNA. We're doing something that's really not intrusive in the type of information that we can collect. And so is there any difference between that and a fingerprint? It's really just in its potential, and the potential is unrealized yet. So that's what I think will happen, and I think there's no meaningful difference, but I bet the ACLU has a different opinion. Okay.
Yeah, so to confess some ignorance here, I haven't worked for the ACLU on this particular issue. So, I know the ACLU has not opposed the fingerprinting of arrestees. We have opposed the collection of DNA from arrestees, I think because of a view regarding the sensitivity of the data collected, and also there's some sort of equal protection concerns about collecting this data from people who haven't, to the extent there's a stigma associated with it, you're inflicting on people who haven't actually even been charged with a crime. And so I think that's also some of the ACLU's concerns about keeping DNA samples forever from people who've merely been arrested. But again, this isn't an area I've worked in, so that's as far as I can go.
Yeah, let me just say one more thing on that, which is the second part of the case is looking at, right, first is the collection, and second is the storage of DNA itself. And the hit of a database over and over again in which a person's information is actually stored. And the problem with the split is, even though that has some intuitive appeal, right, which is to think there's something different and problematic about having your information in a database, it doesn't seem like the Fourth Amendment has anything to say about that second question. And so while there might be statutory protections against that second issue, which is putting your information in a database and it coming up over and over again, at that point, what's the legal interest that you have in the sample that's there? Well, when I was talking in my talk about how, real property law is what's really animating a lot of this information, once the DNA is separated from you, you don't have any legal claim in that. So it's unlikely that second issue is going to win the day for ACLU.
Yes, over here.
You had talked about PTSD. A lot of our soldiers come back with that, as well as traumatic brain injury. I'm not sure how good a job we're doing of treating them, so I was curious to hear you out a little bit on reducing and eliminating PTSD.
Yeah. So, it's interesting. I was reading an article this morning about a particularly interesting conundrum about this. So ADHD drugs, which are quite popular and which we have, in fact, many people in the military are on ADHD drugs, which are good because they can increase wakefulness and concentration, have an unfortunate side effect, which is the increase of norepinephrine that's available in the brain is actually part of the critical part of storage of fear associated with memory. So the reason you remember an event that was traumatic so much more strongly than you remember an event that was not traumatic is because the amygdala, the region in your brain that's important for emotional processing, is activated. So your kind of fight or flight response is activated when you experience some kind of horror. And when it's activated, the consolidation of the memory is stored together with it much more strongly. So the availability of norepinephrine in your brain increases the strength of storage of a memory. And ADHD drugs might increase the amount of PTSD that we have because it's increasing the availability of norepinephrine in the brain, meaning that we have even stronger storage of those memories. But you could interrupt and make less available norepinephrine in the brain. You could block the pathway that has norepinephrine in the brain so that when you experience a horrific event, it isn't stored as kind of tightly bound. So in subjects that they've given both scenarios to, like have somebody watch a horrific event, have somebody watch a horrific event with more norepinephrine in their brain, and then visit them a week later and 2 weeks later and a month later, the person who had norepinephrine has a very vivid and clear memory of the event. The person who didn't, that memory has degraded and faded over time. And there's a 24-hour window after which you experience a traumatic event. That's the critical period for consolidation of the memory, which means if you go into a hospital room or if you're on the field and you are in a place where you actually could have access to one of these drugs during that critical 24-hour period, it could substantially block the consolidation of the fear associated with your memory. So you'd remember the event, but you wouldn't have that strong fear and emotional response coded with the event itself. Cool stuff, I think. Yeah.
So how about over here?
Thank you. This is great stuff. First question is, where do we line up for hugs?
Right outside.
The real question is, the area of defense support for civil authorities is really a growing one, as I understand it. And I'm wondering whether there's an open dialogue being generated now with ACLU or other civil liberties organizations in order to promote positive use of these very valuable technologies for disasters immediately, but also into the future, so we don't run up against some of our fighting each other when we really need to engage certain technologies and capabilities in very fast-breaking, time-sensitive scenarios.
Thank you for the question. If those conversations are occurring, they're occurring at a much higher level than mine. I would hope they would be, particularly in light of the pending legislation in 11 different states. I mean, we have bases in those states, whether they have remotely piloted aircraft or not. And some of, I've read the Texas proposal as an example. And some of the language is pretty broad. And, the questions are, okay, they didn't caveat the word, manned in front of it. It just says, via aircraft. So what if we have a sensor on our aircraft, but we're not a UAV? Will this apply to us? Because actually the Texas legislation not only creates a civil liability situation, but also criminal penalties. And so, that's an interesting issue. And then you also have issues of, okay, the sovereign immunity doctrine. We say, well, we're the feds, so we're good. We don't really so much care about the states. And I don't know that that's really a good kind of position to take, because if you're taking that position, usually it's because you've already been hauled into court, right? So you raise a great policy question that I agree, sir, is something that should be addressed. And whether with the ACLU or directly with the state legislatures in the appropriate manner, I think that those are discussions that do need to occur.
So I'll just add that the ACLU doesn't oppose the use of drones domestically, depending on how they're used. There are many legitimate uses of this technology. A common one that's given, for example, is being able to send an unmanned aircraft to observe an ongoing forest fire rather than a manned aircraft is a much safer thing, and the ACLU is certainly not opposed to those types of uses. We were fairly surprised when a couple of years ago we learned that Customs and Border Protection had put its drones at the service of a local police department that was engaged in an operation in North Dakota. We had sort of just been unaware of what was happening, and we learned about that through a widely read story in the LA Times, because I think Americans in general just didn't understand that drones were coming to the U.S. and not just were coming, but were already here in those capacities. And so I think that really sparked the issue. We really first got involved in this issue back in December of 2011 when we issued a report setting out some preliminary guidelines on what we think, what kind of regulations should be in place to make sure that when drones are used in the United States, they're used in a way that both takes advantage of the technology's benefits, but also safeguards Americans' rights. I think the transparency concerns that you raised are real ones to us. Our primary concern with drones in the United States is they not become sort of generalized tools of surveillance, but that they be used, for example, to investigate specific instances of wrongdoing. Interestingly, this is probably the only issue I've worked on while I've been at the ACLU. We've been outflanked by the right. It was the Republican National Committee that put into its party platform in this past year's campaign that safeguarding Americans from unwarranted uses of drones was an important objective. And it's really sort of Tea Party Republicans around the country and state legislatures who've introduced much of the legislation that we're concerned about, often with Democratic support and the ACLU's sort of civil libertarian support. But this is not an issue that's only concerned of one political party or faction, which is why I think it's gained so much traction around the country.
Had you been reading my mind, you would have heard me say, this is really cool. I really appreciated all three. My question is for Professor Farahany. I was captured by your slide on neuropsychopharmaceuticals, which, as a guy who lived in Germany for 10 years, I really appreciate the length of that word, all one word. But at any rate, on the slide, sorry, Wolf, I'm sorry. Entschuldigung. I was captured by the slide on enhancing soldiers and targeting others and then robo-soldiers. Have you done any thinking about what the implications are for international law, the law of war, and so forth? Because the reason I ask this is the Swedish Defense College has come to us and has asked us to do joint research into human enhancement on the battlefield. Mm-hmm. And to some extent, our reaction is there are a few people talking about it, but it isn't very sophisticated. One guy wrote an article claiming this was a violation of chemical warfare. What, chemical warfare against yourself? Go read the law. And we also see possibility in terms of, for the law of war people, precautions in attack, because if you have a human-enhanced system, that system you may be obligated as a matter of law to use the human-enhanced system as distinct from the other. But we kind of drew the conclusion that we're not seeing a lot of legal implications. I mean, operationally, the implications are huge.
Yeah.
But legally, I was just wondering if you all thought about it, or you know anyone doing research?
Yeah, so first I'll commend you a wonderful book, not by a legal scholar, but the best book in this area, which is called Mind Wars by Jonathan Moreno. And he's written most extensively on neurosecurity, and he goes through some of the international treaties that might be implicated, likewise concluding that there probably isn't any implication for existing treaties except for maybe the Universal Declaration of Human Rights because of the ways in which it might actually be used or implicated, and also potentially, dealing with issues of command responsibility, right? Because as you think about making individuals in the field less autonomous, so here's just an example. One thing that has been worked on is the integration of real-time feedback from helmets to command center for one one potential application. So your visual cortex processes targets far faster than your conscious awareness of it does. And you could real-time feedback, send back information from visual cortex to command center and actually execute on a target faster than the person in the field might be able to react and process the information that they've seen. And who is responsible if, who's responsible for the decision that's made ultimately? And thinking about disaggregating brain-machine interface, the person in the field or the robo person in the field from the person who's actually making the decisions, these have implications for who you hold responsible for different actions. Now, does that implicate international treaties? Probably not. And international treaties don't seem to deal with most of this. But there have been two reports that have been issued. One is Emerging Technologies in the Army, I think is what it's called. And the other one is the National Academies report that looks at emerging neurotechnologies for the military. Both of those also go through some of the different potential legal implications. But all that being said, the law has not caught up with the technologies. And as for whether or not we already have pretty sophisticated technologies that are available, the answer is yes. We have some pretty extraordinarily sophisticated technologies that are already available and that DARPA has funded significant programs around. There aren't enough legal scholars studying this issue.
Over here.
You may have recruited some today.
Hi,
I
I wanted to thank you all for your comments today. It's been fascinating. My question is for Professor Farahany. And at the beginning of your talk, you mentioned that intellectual property law might have something to say. And you mentioned how if you discard your DNA, you aren't really discarding it. But I wanted to hear a little bit more about how you thought IP law might help in this area, and also, relatedly, why you might not look at the First Amendment instead, and how these kind of surveillance techniques could interfere with the freedom of expression and the freedom of association.
Yeah. So first of all, I do think you should look at the First Amendment. There isn't good First Amendment doctrinal history that would support significant freedom of thought outside of academic freedom of thought. And it's kind of an indirect association for freedom of association. I think there are arguments that could be made. I don't know about the strength of those arguments under the First Amendment, but I certainly have been making First Amendment arguments in that context. Intellectual property law. So intellectual property law is an interesting analogy for us to think about informational privacy. It has some limitations as an analogy. So if we think about privacy law in the United States as being almost exclusively tied to seclusion interest, right? So I hide behind my door or in my home, and when you come physically into my space, you've intruded upon my space. That's great, but again, it doesn't work when the things we're interested in keeping private are informational privacy, like the content of your emails versus the headers of your emails. A lot of people have argued that the content of your email isn't something that you voluntarily expose to the public, even if the subject heading and the to from is like the address on the outside. Well, the reason I use those four categories of identifying, automatic, memorialized, and uttered information is those last two categories, memorialized and uttered information, we might think of those a little bit like what an author does, which is to originate information, right? So if I originate my thoughts, is that really far different than when I write those thoughts down? I'm still the author and the originator of that thought and idea. Or the memories that I have, each person's memory of an event, each of your memories of this event will be very different because you've cultivated your own memories and your own experience, and your experience is very different from the next person's experience. So informational privacy already protects those categories of information, which is memorialized information and uttered information, but largely under copyright law. And copyright law and intellectual property law isn't really designed to protect your privacy, while property law is in part designed to protect your property. So how can IP law help us? IP law can help us primarily because it is long since understood that the property you own, the physical, tangible instantiation of an idea, is different from the information inside. It's unbundled these things. And by unbundling these things, it showed us that there are different interests that are at stake. And we need to do the same thing when we talk about privacy in today's world, which is we have to unbundle the physical intrusion from the secrecy. And we've got to figure out how, if at all, we want to protect the secrecy, how, if at all, we want to protect the information. And I will say, I left a bunch of copies of this article, Searching Secrets, on the table out there. If you want to explore this idea in further detail, that kind of goes into, in depth, this idea.
Hi, Chris Schrader from Duke Law School. And for those of you who saw me come in 5 minutes ago, I've been watching the whole thing on the web, so. A very nice panel. Full disclosure, I've just returned from 3 years at the Department of Justice running the Office of Legal Policy, which works on some of these surveillance and emerging technology issues. But I don't have an axe to grind. I just have a question for Ms. Crump by way of information, and actually two questions. They both turn, though, on the distinction between cell site location information and GPS location. When your cell phone is interacting with a call, it is signaling off a unique cell tower, and that's a different kind of information. It's less geographically specific in most instances than the GPS information that your phones can also provide. And my understanding is that telecom providers are not currently storing GPS location information. So if a law enforcement agency wants to get that kind of information, they've either got to know that Apple has got a file on the iPhone that is doing it for them, or perhaps one of the apps is storing that information for them. But typically not. My understanding is the apps don't typically store, many of them don't, some do. And so one question is that your understanding too, that the telecom providers are not storing the GPS more precise information? And then the second part is, does the ACLU draw a distinction between, for protection purposes, between those two types of information? Because as I say, the one is less geographically precise than the other. And as to cell site, the less precise kind, it's my understanding also that the providers don't store that information historically except when you initiate and terminate a call. So that if your phone is on, but you're not calling, it's my understanding at least that the Verizons and the T-Mobiles and so on are not compiling a record that would, as a matter of historical information, be able to tell somebody where you've been, unless you're on your phone constantly, making short calls, and that enables that kind of electronic trail to be compiled as part of their business records, because one thing they do when registering a call is note a bunch of information about that call, and includes the cell tower, and then when you hang up, they also note that information, but don't note your location information again until you make another call. So both as a matter of, do I roughly have my facts right in your others jibe with yours? And then the question is, does the ACLU draw a distinction between the two types of information for purposes of the kind of protection they ought to have?
So your factual understanding and mine are similar, that the carriers, when it comes to the carriers storing historical data, that tends to be cell site data, and it's not GPS data. And that GPS or similarly precise data, such as triangulated cell site information, is generally created on a real-time basis after law enforcement, for example, obtains an order requiring the cell phone company to create those records. In terms of the distinction between them, and does the ACLU think that distinction makes a legal difference? It's a little hard to say, just because it depends how precise the cell site data is. There are people such as University of Pennsylvania professor Matt Blaze, who have testified before Congress that as cell phones have proliferated and as we use more and more smartphones that demand more data, the number of cell towers that are being used, particularly in dense urban areas such as New York City, has increased, and therefore the precision of the cell site data is rapidly improving. Also, people increasingly have access to femtocells, which if you have really bad cell phone reception in your house, right, and you complain enough to whoever your cell carrier is, they will give you sort of a small cell site of your own, right? And so for those reasons, the ACLU has advocated an across-the-board warrant requirement for access to both types of information. But that's not to say that that we don't think there's any difference between them at all.
Great. Well, thank you so much to our panel. That was excellent.